There's a strange thing that happens when someone spends years saying they want privacy and then voluntarily walks into one of the most public courtrooms in the world to tell their story again. It isn't loud at first. It doesn't announce itself. But the contradiction hangs there, quietly, like humidity before a storm. On Wednesday morning in London, Prince Harry took the witness stand at the High Court, not as a bystander, not as a symbolic claimant, but as the central figure in a case accusing one of Britain's most powerful newspaper publishers of unlawful information gathering, hacking, deception, the commissioning of illegal acts, all to expose private details of his life. But before we continue, please don't forget to like, subscribe, and turn on the notification bell for updates. This was not a new fight. It was not even a new courtroom. But something about this moment felt different. Observers noticed it almost immediately. The tone, the pacing, the way answers stretched, then tightened, then drifted into something more emotional than precise. And that's when the unease began to set in. Because this case is supposed to be about newspapers, about journalism ethics, about what is lawful, what is not, and what evidence can actually prove the difference. But the longer Harry spoke, the harder it became to ignore the possibility that this courtroom wasn't just testing the conduct of the press. It was testing him. And that matters, not historically, not symbolically, but right now. Why now? Because this trial arrives at a moment when patience is thin, credibility is fragile, and institutions that once absorbed shock without reaction are starting to respond in quieter, sharper ways. Because this is no longer about a single headline or a single intrusion. It's about a pattern of grievance, of exposure, of repeated public reckoning. And because, for the first time, Harry is not speaking through interviews, documentaries, or memoirs. He is speaking under oath. That changes everything. The case itself accuses the publisher of the Daily Mail and the Mail on Sunday of carrying out or commissioning unlawful activities to obtain private information, allegations the publisher has rejected outright, calling them preposterous and without foundation. Their position is blunt. The stories in question were published decades ago, were not legally challenged at the time, and were based on legitimate journalistic sources. This legal standoff is scheduled to run more than 2 months, concluding on March 26th, with a ruling expected later from the presiding judge, Matthew Nicklin. 2 months. That alone tells you something. This isn't a quick vindication. It isn't a dramatic showdown designed for instant moral clarity. It's slow, procedural, technical, and emotionally unforgiving. And that's where the danger lies. Because courtrooms don't reward narrative passion. They reward evidence. They reward restraint. They reward precision. And Harry didn't always sound precise. At times, he sounded convinced, deeply convinced. At other times, he sounded uncertain, filling gaps with belief rather than documentation. And occasionally, he sounded irritated by the very structure designed to test his claims. That tension between conviction and proof is where this story truly lives. Not in the headlines, not in the old articles, but in the uncomfortable space between what someone feels happened and what they can actually demonstrate. It raises an uncomfortable question that hangs over this entire case. What happens when a man who has built his public identity around personal truth is asked to meet legal truth instead? And perhaps even more unsettling, what happens when those two truths don't fully align? This trial is happening against a backdrop of something else, something less visible, but no less important. Royal tolerance. For years, the royal family absorbed criticism, accusation, implication. They did so mostly in silence, relying on time, tradition, and institutional gravity to do what they've always done, outlast the noise. But silence isn't the same as infinite patience. And lately, there are signs, subtle ones, that the internal temperature has changed. This case, unfolding in a London courtroom, has ripples far beyond the legal arguments. Because Harry is not just any claimant. He is still a prince, still tethered, however loosely, to an institution that values stability above all else. Which is why what happened quietly, away from the cameras, matters so much. Because as Harry testified, word began to circulate. Not publicly, not officially, that lines had been crossed. Not legally, not even intentionally, but symbolically. At the center of that unease was a name that had not been expected to surface at all. Catherine, not as a litigant, not as a witness, but as a point of reference, and, according to palace sources, a point of offense. How does someone offend Catherine without meaning to? That's the question insiders began asking. Because in the world Harry once inhabited, Catherine represents something very specific: continuity, discretion, restraint. She is the embodiment of what the institution wants the future to look like. And when her name becomes entangled, even indirectly, in a public, emotionally charged legal battle, the response is not emotional. It's procedural, which brings us to another figure who does not act impulsively, does not seek attention, and does not speak unless necessary. Princess Anne. And doesn't issue public rebukes. She doesn't leak feelings to the press. She intervenes when boundaries are crossed. And she does so privately. And this time, she intervened. What exactly was said has not been confirmed. It likely never will be. But multiple sources describe the message as stern, unmistakable, and deliberately narrow in focus. It was not about the case itself. It was not about guilt or innocence. It was about conduct. And conduct, in royal terms, carries weight. All of this was unfolding while Harry continued to testify, while his words were being recorded, dissected, preserved. Words spoken in court don't evaporate. They don't soften with time. They sit in transcripts, waiting. And here's the part that complicates everything further. Harry did not walk into that courtroom alone, emotionally speaking, because while Meghan Markle was not present on the stand, her influence on Harry's worldview, his sense of siege, his emotional framing of events, is impossible to separate from how he experiences confrontation now. This isn't about blame. It's about reinforcement. Years of shared narrative. Years of perceived injustice. Years of telling and retelling the same story until it hardens into certainty. When that certainty meets cross-examination, the result is rarely clean. Some observers described Harry as defiant. Others described him as exhausted. A few described him as angry, not explosively, but internally, like someone who feels misunderstood and is tired of explaining why. And that's where this case becomes something else entirely. Because the courtroom doesn't care how tired you are of explaining. It cares whether the explanation holds. This is the moment where a personal crusade becomes a legal risk, where emotional authenticity is tested not by public sympathy, but by judicial scrutiny. And the longer this trial stretches on, the more Harry speaks, the more questions emerge. Not just about what newspapers did 20 years ago, but about what Harry is doing now. Why he keeps returning to these arenas. Why resolution always seems just out of reach. Why each attempt at closure opens a new front. And perhaps most troubling of all, what if this case, intended to reclaim control, actually exposes how little control he has left? That is not a conclusion. It's a tension, and it's one that only grows as the trial continues. Something changed before anyone could quite explain what it was. Not a bang, not a gasp, not even a raised voice. Just a pause. The kind that makes people look up from their notebooks without realizing why. When Prince Harry took his place in the witness box, the room had already settled into its familiar rhythm. Lawyers arranging papers. The judge scanning documents. Journalists leaning forward, ready to capture the quotable line, the stray phrase that might become tomorrow's headline. It all felt routine, procedural, almost dull. And then Harry began to speak. At first, nothing seemed off. He answered questions carefully, even politely. His voice was steady, measured. He looked prepared, not rehearsed, exactly, but alert, focused. But within minutes, observers began to notice something subtle. The cadence. His answers didn't move cleanly from question to conclusion. They looped, hesitated, sometimes circled back on themselves, as if he were trying to locate a feeling before locating a fact. It wasn't dramatic. It wasn't erratic. It was strained. Courtrooms are good at detecting strain. They are built for it. Every inch of the process is designed to apply pressure slowly, almost invisibly, until inconsistencies surface on their own. And this courtroom had seen many witnesses like Harry, confident, emotionally invested, certain of their own narrative. But Harry wasn't just any witness. He wasn't there to recount a single event or transaction. He was there to explain years, decades, of alleged intrusion, suspicion, belief. That's a heavy thing to carry into a witness box, especially when the standard isn't sincerity, but proof. The first questions were straightforward. Background. Context. Establishing why he believed certain articles published by the Daily Mail and the Mail on Sunday had relied on unlawful information-gathering techniques. Harry spoke about patterns, about instincts, about what he felt could not have been obtained legitimately, and that word, felt, hovered in the air longer than anyone expected. Opposing counsel didn't pounce on it. Not immediately. That would have been too obvious. Instead, they let Harry continue. Let him describe how he'd read articles years after they were published and felt a sense of violation retroactively. How connections formed in his mind over time. How suspicion hardened into certainty. There is something almost humanely cruel about that tactic. Letting a witness talk themselves into a corner without interruption. And slowly, that's what seemed to be happening. Harry would begin and answer with confidence, then qualify it, then lean on belief rather than documentation, then return to confidence again. It created a rhythm that felt emotionally persuasive but legally unstable. You could see it on the faces of the lawyers. Not triumph, not concern, calculation. They were listening not for what Harry was saying, but for how he was saying it. Because in a case like this, tone matters almost as much as content. At one point, Harry appeared visibly frustrated by a question that asked him to separate what he knew from what he inferred. He paused, not for a dramatic beat, but long enough for the silence to register. And then he answered. The answer wasn't evasive. It wasn't hostile, but it was imprecise. He spoke about how, given what he now knows about the press, it seemed implausible that journalists could have obtained certain details without crossing legal lines. That phrase, seemed implausible, landed with quiet weight. Because courts don't operate on plausibility. They operate on demonstration. And as the morning wore on, a pattern emerged. Whenever Harry spoke about emotion, the room felt engaged. Whenever he was asked to anchor those emotions to concrete evidence, the energy shifted. This wasn't about intelligence. It wasn't about preparation. It was about the collision between two very different ways of processing reality. Harry has spent years in spaces where personal truth is paramount. Interviews, documentaries, memoirs, speeches. In those arenas, lived experience is the ultimate authority. But a courtroom doesn't grant that privilege. Here, memory is not evidence unless it can be corroborated. Belief is not proof unless it can be substantiated. And that distinction, cold, procedural, unforgiving, began to weigh on him. Observers noted small signs. His posture stiffening, his answers growing longer, a faint edge creeping into his voice when pressed on specifics. At one point, he seemed to challenge the premise of a question rather than answer it directly, a move that might feel natural in conversation, but lands awkwardly under oath. It wasn't a meltdown. It wasn't chaos, but it was enough to make seasoned court reporters exchange glances. Because they've seen this before. The moment when a witness realizes, maybe subconsciously, that the room is not on their side, that sympathy is irrelevant, that the rules are fixed and emotion doesn't bend them. What made this particularly striking was Harry's awareness of optics. He looked out occasionally, not to the gallery, but toward the judge, as if searching for acknowledgement, for understanding. But the judge, Matthew Nicklin, remained impassive. That's not indifference. That's discipline. Judges don't reassure witnesses. They don't validate feelings. They observe. And Nicklin was observing everything. There's an old saying among trial lawyers. The most dangerous witness is the one who believes the court is there to hear their story. Because the court isn't there to hear a story. It's there to test it. By midday, the atmosphere in the room had shifted noticeably. Not hostile, not adversarial in a theatrical sense, but taut. As if everyone understood that the easy part of the testimony was over. Harry had done what many witnesses do in the early stages. He had laid out his emotional foundation. He had established why this case matters to him personally. What came next would be harder, because the next phase wouldn't ask him how he felt. It would ask him how he knew. And here's where something else became apparent. Harry seemed increasingly irritated by the implication that his belief might not be sufficient. Not angry, irritated, as though the system itself was being unreasonable for not accepting what felt obvious to him. That irritation manifested in subtle ways. A slight tightening of the jaw, a quicker pace in his answers, an occasional rhetorical flourish that felt more like an argument than a response. Those moments are dangerous in court. They signal not dishonesty, but resistance. Resistance to the idea that one's internal certainty is not enough. And again, the lawyers did not interrupt. They let him speak. Because every extra word is a risk. One legal observer later described the mood as watchful. Not skeptical, not sympathetic. Watchful, waiting to see whether Harry would adapt or double down. And then came the first real pivot. A question that didn't challenge Harry's feelings, but reframed them. It asked whether he could identify a specific article, a specific method, a specific illegal act, and tie them together without inference. Harry hesitated. Not long, but long enough. And when he answered, he leaned again on pattern, on instinct, on what he described as an unavoidable conclusion. It was in that moment that the temperature in the room shifted decisively. Because the court wasn't hearing new information anymore. It was hearing repetition. And repetition in testimony doesn't strengthen a case. It exposes its limits. This is where courtroom psychology becomes ruthless. The more a witness repeats the same justification in slightly different words, the clearer it becomes that there is nothing else to add. And for the first time, some observers began to wonder whether Harry's greatest strength, his emotional transparency, might also be his greatest weakness in this setting. That question lingered through the afternoon session. It lingered as Harry continued to answer questions. It lingered as the lawyers quietly adjusted their strategy. It lingered as the judge took notes, expression unreadable. Because this wasn't about whether Harry believed he had been wronged. Everyone in that room accepted that he did. The question was whether belief could survive scrutiny. And there was another layer to this. One that didn't register immediately, but would become clearer as the day wore on. Harry seemed to be testifying not just against a publisher, but against time. Against the years that had passed between publication and complaint. Against the absence of contemporaneous legal challenges. Against memories reshaped by later revelations and narratives. Time is an unforgiving cross-examiner. It blurs details. It strengthens emotion. It erodes precision. And the court was acutely aware of that. By the end of the day, the courtroom had settled into a new equilibrium. The initial novelty of Harry's presence had faded. The emotional framing had been established. What remained was something colder. Assessment. How would this testimony hold up over weeks? How would it sound when read back, stripped of tone and context? How would it interact with documents, records, and counter-arguments still to come? Those questions hung in the air as proceedings adjourned. Harry stood, gathered his papers, and left the witness box. But the pressure did not leave with him. Because the first day had accomplished something unexpected. It hadn't clarified the case. It had complicated it. And as Harry prepared to return to court, unaware of the quiet conversations happening beyond the courtroom walls, one thing was becoming increasingly clear. The trial was no longer just about what newspapers did. It was about how Harry would endure the process designed to question everything he believed. There's a question that courts almost never ask out loud. They don't need to. It hovers over the proceedings, unspoken but unmistakable, shaping everything that follows. Why now? Not in the emotional sense. Not in the moral sense. In the procedural sense. Why this case, at this moment, after so much time has passed? It's an uncomfortable question because it doesn't accuse anyone of bad faith. It doesn't imply dishonesty. It simply introduces gravity. The kind that pulls narratives back toward chronology, documentation, and consequence. For Prince Harry, that gravity arrived early on the second phase of questioning. Because once the courtroom moved past tone and demeanor, it turned to structure, to timelines, to dates, to the slow, unglamorous architecture of legal accountability. And that's where the case began to feel old. Not irrelevant, not meaningless. Old. The articles at the heart of Harry's allegations were not fresh intrusions. Many of them were published 20 years ago or more, a fact the publisher has leaned on heavily. At the time of publication, they say, there were no formal complaints. No legal action. No challenges alleging unlawful information gathering. That absence matters in court, not as proof of innocence, but as a complication. Because the longer the gap between publication and complaint, the heavier the burden becomes on the claimant to explain not just what happened, but why it wasn't challenged sooner. Time doesn't invalidate harm, but it does test memory. And memory, in law, is a fragile thing. Harry's legal team framed this delay as part of the harm itself, arguing that systemic practices only came into clearer focus years later, as revelations about phone hacking and press misconduct emerged more broadly. That argument has precedent. It's not unusual, but it's not automatic either. Courts don't accept delayed realization at face value. They interrogate it, and that interrogation began to expose fissures. Harry described reading articles years after publication and connecting them, retroactively, to what he now understands about unlawful information gathering. He spoke about how his perspective evolved, how patterns emerged only with time. That makes emotional sense. But legal sense is less forgiving, because the court must ask, if the realization came later, what changed? New evidence? New testimony? New admissions? Or simply a new interpretation of old material? That distinction matters more than it seems. A reinterpretation doesn't prove illegality. Evidence does. And as the questioning progressed, it became increasingly clear that much of Harry's case rests not on newly discovered documents, but on re-evaluated assumptions. Assumptions about how journalists operate. Assumptions about what could or could not have been obtained lawfully. Assumptions about the inevitability of wrongdoing. Assumptions are persuasive in conversation. They are brittle in court. Opposing counsel approached this carefully, almost delicately. They didn't mock the timeline. They didn't dismiss the emotional impact. They simply asked Harry to situate his claims within specific years, specific publications, specific methods. And each time they did, the same tension resurfaced. Harry could articulate why he believes the stories were invasive. He could articulate how they made him feel, even years later. But pinning those feelings to provable unlawful acts remained elusive. This is where the publisher's pretrial statement loomed quietly in the background. They have called the allegations preposterous and without foundation. Strong language, yes, but carefully chosen. It frames the case not as a dispute over impact, but over evidence. They've argued that the stories were the product of responsible journalism based on legitimate sources. That claim doesn't need to be true to be effective. It only needs to be plausible enough to introduce doubt. And doubt is a powerful ally in court. Harry's team attempted to counter this by emphasizing systemic misconduct, the idea that the press environment of the time normalized unlawful behavior to such an extent that legitimacy itself becomes suspect. That argument has emotional resonance. It also has limits. Courts prefer specificity over atmosphere. They want to know who did what, when, and how. And here, the case began to show its age. Records are missing. Sources are unnamed. Memories are filtered through years of public discourse and personal reflection. This isn't anyone's fault. It's simply the reality of bringing decades-old grievances into a live courtroom. At one point, Harry was asked whether he had any direct knowledge, not belief, not suspicion, of journalists commissioning unlawful acts in relation to specific articles. He answered honestly, no. He spoke instead about what he now understands about the industry, about what seems likely given the nature of the information published. Likely is not illegal. That distinction, again, landed quietly. And it raised a deeper question, one the court will have to grapple with long after testimony concludes. Is it enough to show that unlawful practices existed in the industry at the time? Or must a claimant demonstrate that those practices were used in their specific case? Harry's testimony suggests he believes the former should imply the latter. The law does not always agree. This is where the case becomes less about Harry and more about precedent. Because if the court accepts that industry-wide misconduct can be presumed to apply to individual cases without direct proof, the implications stretch far beyond this trial. That's not a small thing. And courts are cautious with small things that lead to big consequences. As the questioning continued, another issue emerged, one that has nothing to do with newspapers and everything to do with narrative consistency. Harry's recollection of how he experienced certain stories has evolved over time. That's human. It's expected. But when past statements, interviews, and writings are placed alongside current testimony, differences become visible. Not contradictions, but shifts in emphasis. Moments that were once described as intrusive now carry heavier emotional weight. Events that were once footnotes now feel central. Again, this isn't dishonesty. It's reflection. But reflection complicates testimony. Because the court must decide which version of memory carries legal weight, the immediate reaction at the time of publication, or the retrospective understanding shaped by years of discussion, advocacy, and analysis. There's no easy answer. And the court isn't required to be generous. This tension between evolving personal narrative and static legal record sat at the heart of the day's proceedings. Harry seemed increasingly aware of it. At times, he appeared to preempt questions, explaining context before being asked. At other times, he seemed to bristle at the implication that his understanding might be incomplete. That bristling matters, because it signals something subtle but important. Resistance to the idea that time may have altered perception. Witnesses who acknowledge that possibility often fare better than those who resist it. Resistance reads as certainty. Certainty reads as inflexibility. And inflexibility under cross-examination can be dangerous. By mid-afternoon, it became clear that this case was not moving toward a dramatic reveal. There would be no smoking gun, no sudden confession, no decisive moment where everything snapped into clarity. Instead, it was accumulating weight. Weight from time. Weight from absence. Weight from repetition. The court was beginning to see the shape of the case, and that shape was complex, but not explosive. And that may be the most unsettling thing for Harry, because explosive moments dominate headlines. Complex ones linger. They invite interpretation rather than reaction. And interpretation is where control slips. As proceedings wrapped for the day, one could sense a recalibration underway. Not a dismissal of Harry's experience, not an endorsement of the publisher's defense, but a narrowing of what this case can realistically prove. That narrowing doesn't mean failure. It means constraint. And constraints are where personal crusades often struggle, because they demand acceptance of limits. Limits on what the law can do. Limits on what memory can establish. Limits on how far retrospective justice can reach. Harry left the courtroom that day with his narrative intact, but his legal path more sharply defined. The question now wasn't whether the press had wronged him. It was whether the law could be persuaded to say so. And as the trial stretched ahead, weeks of documents, witnesses, and arguments still to come, another pressure began to build quietly in the background. Because while this case was anchored in the past, its consequences were moving steadily toward the present. There's a moment in every long trial when everyone in the room realizes the same thing at once. Not because someone says it, not because a document appears on a screen, but because the questions change. They stop asking what happened. They start asking how you remember it. That shift is subtle, almost polite. And for witnesses who rely heavily on lived experience, it can feel strangely personal, as if their own mind has been placed on the stand. That's where this case drifted next. For Prince Harry, memory isn't just a source of evidence. It's a battleground. It's where years of frustration, suspicion, and self-examination have settled into something that feels coherent, even inevitable. But courts are suspicious of inevitability, because inevitability often arrives after the fact. As questioning resumed, the focus tightened. Lawyers began isolating individual recollections, not to disprove them, but to locate their edges. To see where memory blurred into inference, and where inference hardened into certainty. Harry was asked about how he knew certain details in specific articles could not have been obtained legally. He didn't hesitate. He explained that, at the time, he may not have fully understood how the press operated. But now, looking back, the only plausible explanation was unlawful information gathering. That phrase again. Looking back. It sounds reasonable. It feels reflective. It carries the weight of wisdom gained. But in court, looking back is a double-edged sword. Because hindsight doesn't just clarify. It reshapes. Memory is not a recording. It's a reconstruction. Each time it's recalled, it's subtly altered, colored by what we've learned since, by conversations we've had, by narratives we've adopted. Psychologists have written volumes about this. Courts know it well, which is why they are cautious when witnesses rely heavily on retrospective certainty. The questioning pressed gently but persistently. Were there any contemporaneous notes? Any complaints lodged at the time? Any correspondence indicating suspicion of illegal methods when the articles were published? Harry acknowledged there were not. That admission didn't weaken his sincerity, but it narrowed his evidentiary base. And narrowing is dangerous in a case that already spans decades. He spoke about the shock of reading intimate details of his life in the press. Details that felt too precise, too personal to have been gathered legitimately. Again, emotionally compelling. Again, legally incomplete. Because journalism often relies on proximity rather than intrusion. Friends talk, staff talk, acquaintances talk. People reveal more than they realize, especially around famous families. That possibility doesn't erase wrongdoing, but it introduces alternative explanations. And courts are built on alternatives. At one point, Harry was asked whether he could distinguish between what he personally experienced at the time and what he later came to believe after learning about broader press misconduct scandals. He paused, not dramatically, but deliberately. The pause mattered, because in that silence, something important surfaced: awareness. Harry seemed to recognize, perhaps for the first time out loud, that his understanding of past events had evolved. He admitted as much. He acknowledged that certain connections only became clear years later, after public inquiries, exposés, and legal cases revealed the extent of unethical practices in parts of the press. That honesty was notable. It showed self-awareness. It showed reflection. But it also underscored the core problem of his case. Because evolution of understanding does not automatically translate into retroactive proof. Courts don't punish what seems obvious now. They punish what can be demonstrated then. This is where the tone in the room shifted again, not toward hostility, but toward something cooler. Clinical. The lawyers began to treat Harry less as a narrator of injustice and more as a source of data. They parsed his words. They separated feelings from facts. They returned repeatedly to the same axis: knowledge versus belief. Harry resisted that distinction at first, not aggressively, but philosophically. He argued that lived experience gives one a form of knowledge that cannot always be documented, especially when dealing with covert practices. There is truth in that. But law is not philosophy. Law is a discipline that privileges what can be shown over what can be felt. And the judge, Matthew Nicklin, made that clear, not through rebuke, but through silence. Silence is one of the judiciary's sharpest tools. It doesn't interrupt. It doesn't correct. It simply waits. And waiting forces witnesses to fill the space. Harry filled it. He spoke about patterns again, about the accumulation of incidents that, taken together, made unlawful conduct seem not just possible, but probable. Probability, however, is not certainty. And certainty is what courts require. As the afternoon wore on, a strange inversion began to occur. Harry's emotional clarity grew stronger. His legal clarity grew thinner. The more he explained how deeply these articles affected him, the further the case drifted from the mechanics of illegality. That's not to say the court didn't care about impact. It did. But impact alone does not establish method. And method is the heart of the allegation. This tension began to weigh visibly on Harry. His answers lengthened. His tone sharpened slightly. He began to preemptively defend his credibility, a sign that he felt it being tested. That's understandable. Few things feel more unsettling than having your own memory questioned in a formal setting. It can feel like an accusation, even when it's not. And Harry is not accustomed to having his internal reality dissected in this way. He's accustomed to telling his story, not defending the architecture of how he remembers it. At one point, he was asked whether it was possible that some of the information in question came from people within his own circle. Friends, staff, associates. The question was framed neutrally, almost gently. Harry bristled, not explosively, but clearly. He rejected the suggestion, implying that such leaks would constitute a betrayal, and that betrayal, he argued, was less plausible than unlawful press behavior. That response revealed something important. Harry's internal calculus places emotional loyalty above probabilistic analysis. He trusts his circle, or at least his concept of it, more than he trusts institutions. Again, that makes sense personally. But in court, personal trust is not a defense against alternative explanations. If anything, it introduces them. The court doesn't need to decide who betrayed whom. It needs to decide what is more likely than not, and on what basis. As the questioning continued, it became increasingly clear that Harry's testimony was doing something unintended. It was reinforcing his sincerity, while simultaneously exposing the fragility of his evidentiary framework. That's a dangerous combination, because sincerity invites empathy, but fragility invites doubt. And doubt doesn't need to overwhelm a case to weaken it. It just needs to linger. One observer later described the mood as sympathetic but constrained. That's an accurate phrase. The court wasn't dismissing Harry's experience. It wasn't mocking his belief. It was simply refusing to merge belief with proof. That refusal is not personal. It's institutional. And institutions don't bend easily. As the day drew toward its close, Harry seemed increasingly aware of this. He slowed his answers. He chose words more carefully. He avoided rhetorical flourishes. It was as if he were recalibrating mid-testimony, adjusting his approach in real time. That adaptability may serve him well in public discourse. In court, it's a gamble, because consistency matters as much as clarity, and any visible shift in tone or strategy can be read, unfairly or not, as uncertainty. By the end of the session, the court had learned a great deal. Not about hacking, not about surveillance, but about Harry's relationship with his own narrative. How it has evolved, how it has solidified, how it now resists being unpicked. That resistance isn't defiance. It's protection. Protection of a story that has become central to how he understands his life. But the law does not exist to protect stories. It exists to test them. And as Harry stepped down from the stand that day, one could sense that the testing had only just begun. Because the next phase would not focus on memory at all. It would focus on something colder. Documents. Records. Contradictions. And those things have a way of speaking for themselves, regardless of how anyone remembers the past. What happened when Harry's lived truth met the paper trail? Judges rarely dominate a room. They don't need to. Their power doesn't come from volume or force. It comes from stillness, from the knowledge that every word spoken in their presence is being weighed, quietly, continuously, against standards that don't bend for personality. For most of the proceedings, Matthew Nicklin had been exactly that kind of presence. Measured, contained, almost invisible. He let the lawyers speak. He let the witness answer. He let the process unfold at its own deliberate pace. That, in itself, is a signal. When a judge allows extended testimony without intervention, it usually means one of two things. Either the evidence is flowing cleanly enough to need no correction, or the judge is allowing the record to build, fully, unfiltered, before stepping in. In this case, it was the latter. You could feel it in the pauses. Not the awkward ones. The intentional ones. Moments when a question ended, an answer followed, and instead of moving on, the room simply waited. Nicklin would look down at his notes, make a small mark, then look up again. Those small gestures matter more than people realize, because judges don't interrupt to clarify what they already understand. They interrupt when something doesn't sit right. And up until a certain point, Nicklin hadn't interrupted at all. That was what made the moment he finally did so feel heavier than expected. It didn't come after a dramatic exchange. It didn't follow a heated disagreement. It arrived quietly. After an answer that was earnest, detailed, and emotionally clear, but legally thin. Harry had been explaining, again, how patterns across multiple articles led him to conclude that unlawful methods must have been used. He spoke carefully, trying to balance conviction with restraint. He finished his answer. There was a pause. Then the judge spoke. Not sharply, not impatiently, just directly. He asked Harry to clarify whether he was offering evidence of fact or inference based on later understanding. The distinction was surgical, and it cut straight through the heart of the testimony. Harry answered honestly. He acknowledged that much of his understanding had been shaped over time, informed by later revelations about press misconduct, not by direct knowledge at the time of publication. Nicklin nodded. That nod mattered, because it signaled comprehension, not agreement. From that moment on, the courtroom dynamic shifted. The judge wasn't correcting Harry. He wasn't challenging him. He was framing the case. Framing is everything in law. It determines how evidence is interpreted, how arguments are weighed, and ultimately, how a judgment is written. By asking that question, Nicklin did something subtle but profound. He separated narrative from proof. Not dismissively, not cruelly, but decisively. After that, the questions became sharper. Not more aggressive, more precise. Harry was asked to specify whether particular claims rested on personal observation, third-party information, or retrospective inference. Each category carries different legal weight. Harry navigated those distinctions as best he could. Sometimes he landed cleanly. Other times he drifted. And each drift was quietly noted. The judge did not intervene again immediately. He didn't need to. The framework had been established. From that point forward, Every answer Harry gave was implicitly filtered through the lens Nicklin had just defined. Fact, belief, inference. 3 words, 3 worlds. And only one of them can anchor a legal finding. Observers began to sense it. The atmosphere didn't become tense, it became focused. This wasn't about whether Harry was telling the truth as he understood it. It was about whether the truth he understood could carry the burden he was placing on it. That burden is heavy. Allegations of unlawful information gathering are serious. They imply criminal behavior. They demand proof that meets a high threshold. Nicklin's role is not to empathize with frustration. It's to protect that threshold. And everything about his demeanor suggested he was doing exactly that. There's a temptation, especially in high-profile cases, to read judicial restraint as sympathy or skepticism. But restraint is neither. It's discipline. Nicklin was not reacting to Harry as a prince, a public figure, or a cultural symbol. He was reacting to him as a claimant. And claimants, in court, are not owed affirmation, only fairness. Fairness doesn't mean believing someone. It means testing their claims evenly. As the day continued, Nicklin asked a few more questions, never many, never long. Each one, however, served the same purpose: to clarify scope, to narrow interpretation, to ensure the record reflected not just what Harry felt, but what he could establish. Those questions didn't weaken Harry's credibility, but they did expose the limits of it. And limits are uncomfortable things to confront, especially for someone who has spent years expanding his narrative outward, drawing connections across time and experience. In that moment, the courtroom became something else entirely. Not a stage, not a forum, a boundary. It marked where personal truth ends and legal truth begins. And that boundary is unforgiving. Harry seemed to sense it. His tone shifted again, subtly, but noticeably. He became more careful, more deliberate. He avoided absolute statements. He hedged where he previously asserted. That shift may play well in judgment, or it may raise questions about consistency. It's too early to tell. What is clear is that Nicklin's intervention, brief as it was, changed the trajectory of the testimony. From that point on, Harry was no longer narrating a story. He was responding within a structure, and that structure would not bend to accommodate emotion. As proceedings adjourned, one thing stood out. The judge had not expressed doubt. He had not expressed approval. He had expressed clarity. And clarity, in a case like this, can be more decisive than skepticism. Because when a judge clarifies the lens through which evidence will be viewed, everything else must adjust accordingly. Harry left the courtroom quieter than he had entered it. Not defeated, not chastened, but aware. Aware that the ground beneath him had firmed up. Aware that the latitude he'd previously enjoyed, in interviews, in public discourse, did not exist here. And perhaps most importantly, aware that the next phase of this trial would not be guided by how compelling his story was, but by how well it could survive the framework the judge had just imposed. What happens when the narrative no longer belongs to the narrator? That's the question now hovering over this case. And it wouldn't stay unanswered for long. There are some names that don't belong in a courtroom, not because they're forbidden, not because they're fragile, but because once they're introduced, even indirectly, the context changes, the gravity shifts, and suddenly, what was a legal dispute begins to touch something older, quieter, and far less flexible. That's what happened when Catherine's name began circulating, not in testimony, not in filings, but in conversations around the case. Catherine was never meant to be part of this story. She wasn't a claimant. She wasn't a witness. She wasn't referenced as a source, a subject, or a target of press intrusion. And yet, by the middle of the week, palace watchers, legal observers, and royal correspondents were all asking the same question in hushed tones. How did Catherine end up anywhere near this? The answer is uncomfortable precisely because it wasn't intentional. This wasn't a direct accusation. It wasn't a comparison. It wasn't even a criticism in the conventional sense. It was a drift. A narrative drift that occurs when stories stretch too far, when one person's fight for vindication begins to brush up against the reputations of others who didn't ask to be involved. In Harry's testimony, and in the broader framing of his grievances, a contrast emerged. It wasn't spelled out. It didn't need to be. The idea, subtle but unmistakable, that some members of the royal family were treated differently by the press, that some were protected, that some were spared the intensity of intrusion he experienced. This is a belief Harry has voiced before. It's not new. It's not surprising. But voicing it in the context of a courtroom, where words are preserved, parsed, and replayed, gives it a different weight. Because contrast, once introduced, implies comparison. And comparison, in royal terms, is combustible. Catherine's public image is built on consistency, discretion, and an almost aggressive refusal to personalize institutional dynamics. She doesn't litigate narratives. She absorbs them. She is, in many ways, the embodiment of the system Harry has spent years criticizing, which makes her symbolic presence in this case, however unintended, deeply sensitive. Palace insiders describe a growing discomfort as the trial unfolded. Not panic, not outrage. Concern. Concern that a line was being approached, one that separates personal grievance from institutional implication. Because once the idea takes hold that certain royals were protected while others were exposed, it doesn't just challenge the press. It challenges the monarchy's internal equilibrium. It invites questions the institution is not eager to answer publicly. Questions about hierarchy, about priority, about sacrifice. And Catherine, by virtue of her position and conduct, sits at the center of those questions, even when she says nothing at all. That silence is not weakness. It's strategy. But silence doesn't prevent association. And association, once established, can feel like an offense, even when no offense was intended. This is where the idea of collateral damage becomes relevant. Harry did not set out to involve Catherine. There is no evidence he targeted her. There is no suggestion of malice. But the structure of his argument, the way it frames unfairness and disparity, inevitably casts shadows. And Catherine, as the most visible embodiment of royal continuity, stands in that shadow. This is the point at which the case stopped being just legal. Because legal cases are contained by jurisdiction, royal dynamics are not. What unsettled palace officials wasn't that Catherine was being criticized. She wasn't. It was that her name was being pulled, however obliquely, into a narrative of grievance that she has spent years avoiding. Catherine's role within the family has always been clear. Stability, reliability, non-intervention. She doesn't contradict. She doesn't clarify. She doesn't defend herself in public, which means she also doesn't consent to being used as contrast. And that's where the unease deepened. Because in the royal family, consent matters, even symbolically. One former aide put it this way: when you imply disparity, you imply choice. And when you imply choice, you imply responsibility. Responsibility is the last thing the institution wants attached to Catherine in this context. She is not meant to be a counterpoint. She is meant to be neutral ground. So when Harry's testimony and broader legal posture began to echo themes of differential treatment, the palace did not react publicly. It never does. Instead, it did what it always does when a boundary feels threatened. It escalated internally, not emotionally, procedurally. And that escalation didn't go through press offices or spokespersons. It went through people whose job it is to maintain institutional order when personalities collide. Which brings us, inevitably, to Princess Anne. Princess Anne does not involve herself in drama. She doesn't mediate feelings. She doesn't soothe egos. She enforces lines. Anne's role within the family has long been less about visibility and more about continuity. She understands the monarchy as a machine, one that functions only if individual impulses are kept in check. When Anne intervenes, it is never because someone is upset. It is because something is out of alignment. Sources describe the concern in this case as precisely that. Not outrage. Not offense in the emotional sense. Misalignment. Harry's pursuit of justice, legitimate in its own right, was beginning to graze the institutional integrity Catherine represents. And that, quietly, was deemed unacceptable. It's important to understand what this does not mean. It does not mean Catherine complained. It does not mean she felt personally attacked. It does not mean she asked for intervention. She likely did none of those things. That's not how her position works. The system protects itself, and when it does, it uses people like and not to scold, but to correct course. The message, as described by those familiar with it, was narrow and controlled. It did not address the merits of the case. It did not question Harry's right to pursue legal action. It did not suggest he was wrong to speak about his experiences. It focused on one thing: boundaries. Specifically, the boundary between personal grievance and institutional implication. The boundary between one individual's legal fight and the symbolic roles of others who are not part of it. The warning was not theatrical. It didn't threaten consequences. It didn't demand silence. It clarified expectations. And clarification, when delivered by and carries weight, because and does not clarify twice. What makes this moment particularly significant is its timing. This warning did not come after a verdict. It did not come after escalation. It came early, while testimony was still unfolding. That suggests anticipation, a desire to prevent something rather than respond to it. From the institution's perspective, this makes sense. The longer narratives run unchecked, the harder they are to contain. And once Catherine's symbolic role is entangled in public grievance, disentangling it becomes nearly impossible. Harry's reaction to this intervention, though not public, is described as tense, not explosive, not dismissive, but wounded. Because from his perspective, this is not about Catherine. It's about his truth. And being told, even indirectly, that his truth must be bounded by institutional sensitivities is something he has resisted for years. This is the core fracture that runs beneath everything. Harry believes personal truth should override institutional comfort. The institution believes institutional stability must override personal expression. Catherine exists at the center of that conflict, not as a combatant, but as a symbol. And symbols don't get to opt out. That's the cruel irony. She does everything right. She says nothing. She remains neutral. And still, the mere implication of her presence changes the stakes. This is why palace insiders describe the situation not as a scandal, but as a risk. A risk that Harry's legal battle, if allowed to expand unchecked, could force the institution into a defensive posture it desperately wants to avoid. Because once Catherine becomes part of the story, even indirectly, public sympathy recalibrates. She is not seen as powerful in the same way others are. She is seen as dutiful, and any narrative that appears to cast her as a beneficiary of unfairness, however unintentionally, threatens to backfire. The palace understands this instinctively. Harry, focused on justice and vindication, may not. Which is why this moment matters. Because it marks the first clear signal that the institution is no longer merely observing this case. It is monitoring its spillover. And spillover is what institutions fear most. Legal battles can be lost. Reputations can be repaired. But symbolic damage, once done, is far harder to reverse. As Harry returned to court after this internal warning, he carried something new with him. Not just the pressure of cross-examination, not just the weight of proving his claims, but the awareness that his words now carried consequences beyond his own case. That awareness can sharpen focus, or it can breed resentment. Which one takes hold often determines what comes next. And what came next, according to those close to the situation, was not calm. It was something closer to defiance. Quiet, controlled, but unmistakable. Because when someone feels their truth is being constrained again, the instinct is not to retreat. It is to push harder. And that instinct, in a courtroom and within a royal family simultaneously, is a dangerous one. There is a particular kind of authority that never raises its voice. It doesn't need to. It arrives quietly, carries no theatrics, and leaves very little room for misunderstanding. When it speaks, it isn't asking for agreement. It is establishing parameters. That authority belongs to Princess Anne, and does not issue press statements. She does not brief aides to clarify feelings. She does not posture. When she steps in, it is because something has drifted far enough off course that correction is required. Not discussion, correction. And in this case, the correction was overdue. By the time Anne became involved, the trial had already taken on a life beyond its legal mechanics. The testimony, the commentary, the subtext, all of it was beginning to echo beyond the courtroom walls. Not loudly, not chaotically, but persistently. From the palace's perspective, that persistence was the problem. Harry's case, on paper, is narrow. It concerns allegations of unlawful information gathering by a newspaper publisher. It lives in statutes, precedents, and evidentiary standards. But Harry's way of framing it, emotionally, narratively, historically, has a tendency to expand outward, to absorb grievances, to imply systems, to contrast outcomes. That expansion is where institutions begin to bristle. not because they are guilty, but because they are vulnerable to implication, and understands this better than almost anyone. She grew up watching crises mishandled by excess emotion and rescued by quiet discipline. She understands that the monarchy survives not by winning arguments, but by refusing to be drawn into them. Which is why her intervention, when it came, was surgical. It was not public. It was not documented. It was not even particularly long. But those who were aware of it describe it as unmistakable. The message was not stop. It was stay in your lane. That distinction matters. And did not question Harry's right to pursue legal action. She did not dismiss his grievances. She did not challenge his sincerity. She addressed the spillover. Specifically, the risk that his courtroom narrative, and the broader framing around it, was beginning to touch people and symbols that were not part of the case. And that, from an institutional standpoint, was unacceptable. The monarchy operates on an unspoken contract. Individuals may endure hardship. The institution must remain intact. When the two come into conflict, the individual is expected, however unfairly, to absorb the cost, and has spent her entire life enforcing that logic. She did it during family scandals. She did it during constitutional crises. She did it quietly, without apology. So when she delivered her warning, it carried the weight of precedent. Those familiar with the exchange describe it as calm, controlled, devoid of emotional language, and did not express disappointment. She did not express anger. She expressed expectation. Expectation that Harry's legal battle would remain just that, legal. Expectation that symbolic roles within the family would not be dragged into comparative narratives. Expectation that certain names, once left unsaid, would remain so. This wasn't about protecting reputations in a superficial sense. It was about preserving clarity. Because once narratives blur, once symbols become characters, the monarchy loses one of its greatest advantages, predictability, and does not tolerate unpredictability. What made this intervention particularly striking was that it did not come from the reigning monarch or the heir. That was deliberate. When messages come from the top, they can feel political, strategic, calculated. When they come from, and they feel structural. She is not perceived as ambitious. She is not perceived as image-conscious. She is perceived as necessary. That perception gives her words a kind of moral gravity others lack. Harry understood that immediately. Sources describe his reaction as conflicted, not dismissive, not openly defiant. Conflicted, because on one hand, he recognizes Anne's authority. He grew up under it. He knows her reputation. He knows she doesn't intervene lightly. On the other hand, the message struck at something raw. Because to Harry, this case is not abstract. It is personal. It is tied to years of frustration, vulnerability, and unresolved anger. Being told, even gently, that those emotions must be bounded, managed, contained, that feels like a return to the very dynamics he believes he escaped. This is where the fracture deepens. Harry does not see his narrative as spillover. He sees it as context. He believes that without context, injustice cannot be understood. The institution believes that without boundaries, context becomes contagion, and stands firmly in the second camp. And she is not alone. What Harry may not fully appreciate is that Anne's intervention likely reflects a broader internal consensus. Not collusion, not conspiracy, alignment. An understanding among senior figures that the trial, if left unchecked narratively, could force the institution into positions it does not want to occupy. Positions that invite judgment. Positions that invite comparison. Positions that invite moral accounting. The monarchy avoids those positions at all costs. It prefers silence to self-defense. Distance to explanation. Anne's role is to ensure that preference is respected. What makes this moment particularly consequential is how it intersects with Harry's state of mind during the trial. By this point, he was already under pressure. The questioning had grown more exacting. The judge had clarified the evidentiary framework. The limitations of memory-based testimony were becoming clear. And now, layered on top of that, came an institutional reminder, quiet but firm, that his words carried consequences beyond his own case. That's a lot to absorb, especially for someone who already feels constrained by systems. Some observers believe this intervention may have contributed to a subtle shift in Harry's demeanor in subsequent sessions, not visible to casual viewers, but perceptible to those watching closely. A tightening, a guardedness, a sense that he was navigating not one scrutiny, but two, the courts, and the families. That dual pressure is rare. Most claimants fight institutions from the outside. Harry is doing it from a position that is both inside and outside at once. That liminal position is psychologically exhausting, and Anne, whether intentionally or not, made that reality impossible to ignore. There is another layer here that deserves attention. Anne's warning was not just about Catherine. It was about precedent. If Harry is allowed, even implicitly, to frame his grievances in ways that suggest internal favoritism or differential protection, others may follow. Future disputes, future conflicts, future narratives. The institution cannot afford that. Not because